Bangalore City Flat Owners Welfare Association. I am the current president, and I would like to invite Mr. Anil Kalgi, who is the founder member and then the mentor of the Bangalore City Flat Owners Welfare Association, who is instrumental in many achievements in this area in fixing certain issues which are concerned to many of the home buyers across Karnataka. So I would welcome Mr. Anil Kalgi to enlighten us on the various aspects. One is that what is apartment, and then what are the ownership issues which we are facing today, and then what are the measures we should take to achieve or restore our ownership rights, and then further some solutions related to the issues raised by the members, and then the way forward we will discuss also, and then coming to an end the question and answer sessions will be addressed. So I request everyone to keep your questions ready, or else post in the message group. We will make a record of it. So based on that, we will Miss Malka will be able to take us through the questions, and then the respective questions will be answered by our senior member, Mr. Anil Kalgi. Thank you very much, and I will welcome Mr. Anil Kalgi to open the session. Anil sir, please welcome.
Yes, good morning everybody. Today especially we are organizing this meeting to let us understand. Most of the time we make complaint, this is the problem, that is a problem and everything. Why this problem that we are facing? Most of us, we fail to understand actually what the apartment is basically. When I'm talking what the apartment is, then the question comes is what is the ownership? 99% of the people whom we have gathered over here or across the apartment owners, they think that they are the property owners. So basically, first thing here it is required to understand is what is apartment. I don't know. Many a time we have come across and I try to ask the people what is apartment. They say the building and everything. But absolutely when I look into the sale deed or the ownership that I got, it only talks about my living space. It do not talk anything more than that. So then what exactly the sale deed is? So to understand what the apartment is, let us understand what is the definition of the apartment that is prescribed in the various laws like RERA and the Karnataka Apartment Ownership Act. So let me put to you what the apartment is. Most of us, we are very comfortable in using the word Karnataka Apartment Ownership Act or KAOA. Now let us understand exactly what the apartment is defined here. The definition of the apartment in this act is unless context otherwise requires, an apartment means a part of the property intended for the any type of independent use, including one or more rooms or enclosed spaces located in one or more floors or part thereof in a building intended to be used for residential purposes with a direct exit to a public street, road, highway, or to a common area leading to such street, road, or highway. Now, this is what the Karnataka Apartment Ownership Act says. Now, let us understand, we are also, every one of us, we are very clear. In generally, legally, it is defined as a person who has got a complete control over the property. He can reconstruct it, he can use it, he can modify it, everything. Now let us understand the reality here. Are we in a position to reconstruct the apartment? The answer lies here is no. It is fixed. We can modify it to certain extent internally, but externally we can't change it because that is not the scheme of the apartment ownership piece. So then what is the situation? What exactly? Most of us, actually why we are having problem here? Because most of we are all first generation apartment buyers. When I say the first generation apartment buyers means we don't know many things. Secondly, our background is in such a way that we have come from an independent house where there is a portico, there is a backyard and side spaces, and as a children probably we have played on the ground or a playground. Everything was available. Whether in a place such facilities available, absolutely we do not have such things. That means in the inside the four walls, whatever we can do, that is what is permitted. That is what we call it a apartment. So apartment. Now the question comes is, who is the apartment owner? The definition under the Karnataka Apartment Ownership Act makes it very clear. Apartment owner means a person or a persons owning an apartment and an undivided interest in common area and facility in the percentage specified and established in the declaration. Now, here is the question arises that undivided interest. Friends, undivided interest you will have. That is what sometime it is mentioned in your sale deed. That is what we call it undivided share. Undivided share is different. Undivided interest is different. Undivided share that comes is they mention number of square feet that is not permitted by the law. Secondly, undivided interest which is specified in the percentage wise. That means in the entire property how much percentage of undivided interest you can have. Here the apartment one catch is here. You cannot able to modify anything. The only thing as it is, you are supposed to occupy and do the things. Well, friends, I was talking about what is undivided share and undivided interest. Now, undivided share and undivided interest, where exactly it comes, this can only have an effect provided it is to be owned jointly by all the people. This is exactly where the real estate regulatory law, that is RERA, tells the people that builder shall transfer the common area to the association of allottees. Now, whether it is only in RERA, is there in any other law it is available? Well, before RERA in Karnataka, we had a Karnataka Ownership Flat Act. Karnataka Ownership Flat Act also states the same thing, that on construction of the property, the builder shall transfer the title to the organization of allottees, cooperative society or a company. They make very clear here. That means for the ownership, it is necessary that the builder is supposed to convey the title. When if I say the common area, now let us understand what the common area is defined in the real estate regulatory law. Okay, the common area means here the entire land for the real estate project or where the project is developed in phases, and registration under this act is sought for phases, the entire land for that particular phase. What exactly here he says? He exactly is trying to say here is that the entire project land, okay, has to be transferred to the association of to the association of allottees. This is where why these clauses are being made. Let us understand the reality here. The reality to understand is why these clauses are made, because the transfer of property or buying and selling of a property is governed by Transfer of Property Act. Hope all of you understand. Okay. Now we know Transfer of Property Act provides this and everything. Many a time we do not know what the Transfer of Property Act says. Section 6D of the Transfer of Property Act prohibits selling of undivided share or undivided interest in the property. It is to be shared among themselves only. This is the law that states. So then, if a Transfer of Property Act do not permit undivided share, then how the sale should take place? Is there any provision for that? Well, the Transfer of Property Act further also says that if the property is, that is property here, we should understand very clearly, it is land and the building. Immovable property, what we are defining is land and the building. It is a immovable property and there is an undivided share, if at all. It cannot be sold by the person who is enjoying it. Remember, we have reconciled to a fact by buying an apartment that we are accepted to live in a community living. It is a joint ownership has to be there and a collective ownership. Am I making clear to all of you? You can unmute and say one word and keep quiet. So when the matter is very clear here, it is a community living we have accepted, a joint ownership we have obtained. Now understand what is the sale deed we are having. We are having an apartment where specific areas have been given with undivided share we have been provided, but we have not been provided any specific schedule for Schedule B property because it is undivided. It is only, even though it is mentioned, it is not get alienated or it is not transferred from the original owner of the land, to you all. So then how it is to be done? This is where exactly the real estate regulatory law section 17 says that a common area is supposed to be. This is where exactly real estate regulatory law provides a protection to the apartment buyer that promoter shall execute a registered conveyance deed in favor of a allottee along with the undivided portion of the title in the common area and common area to the association of allottees. Now here the word is very clear. This is where exactly how the ownership of the property, that is property again, it is a land and the building. We have understood very clearly that apartment. Yeah, this is where to give proper effect to your apartment as a property, it is necessary that every apartment owners jointly they should obtain a transfer of the title so that your apartment becomes a property for you. Otherwise, it is just a living space, nothing more than that. Then what is the legal effect of this apartment is all about? In a given situation, the legal effect of all these things is if you are not obtained the conveyance of the title jointly or jointly, then the issue remains is that you are just a possession holder. Very recently, we must have seen one apartment complex in Mahadevpura. Can somebody tell me what is that some elegant something? What is that name of the apartment?
Royal Heritage, sir.
Pardon?
Royal Heritage.
Royal Heritage. Royal Heritage issue, we have seen it. It is a 25 years old project. Metro has acquired the part of the property there and the compensation was to be given. When the compensation was to be given, builder has claimed the property right because the title interest in the property that is called as the land and the building is continued to be vested with the original owner and he has only sold the apartment. This is what precisely gives an inference and it should be an educating thing to all of us is that a mere sale deed of an apartment do not give me the right over the property. That's what we are trying to maintain. Once most of us, we occupy the apartment thinking that we go and check electricity is there. We open the tap, water is coming. We think that everything is correct and everything is completed. We are just a layman. We are not expert in law. Don't know many things. But let us be very clear, sir. Independent house is different. community living is different, and living in a high-rise structures is again a different. Now, why I say these are all the different? It is because everyone have been governed by every of these things have been governed in a different way. A independent house is governed by Karnataka Municipal Corporation Act, or the Municipal Corporation Act, or the BBMP Act in Bangalore. And when it comes to a community living, yes, here is a situation where we are living in a group. Now, what are the things are required? That is what we call it an apartment. The group living concern, you are owning a single unit, that is portion of a building. Then it has to be collectively owned and maintained. The reality in today in Bangalore is that builder have never transferred the building to the apartment owners for the management and maintenance. Now, he has already sold the apartment collectively to everyone as undivided share. So collectively, we stand to be the owner. Friends, you will not become a collectively a owner unless or until the property is conveyed to you jointly. That is what is the royal heritage lesson give to us. Secondly, if at all we have to acquire it, then the question comes is how to obtain the ownership of this. Obtaining the ownership has got many mechanisms. Since you are all independent owner of your apartment, nothing is going to happen. You are the owner of your living space. And the collective ownership which has to be achieved, you have got the mechanism to be followed. Then what exactly the mechanism is? In a said building, all the owners together can go to the sub-registrar office along with the builder and obtain the title transfer. Now, when this is the condition is there to transfer that all the owners again, but already we have got a sale deed. Sale deed you are having is of your apartment. The property conveyance when you are taking collectively, all the people should go. Say, for example, in a building, there are 100 apartments are there, and all the hundreds have been sold as an undivided share to everyone. Then you become owner. No, you will not become the owner. Now question comes how it is to be done. Now again all the 100 people along with the builder should go to the sub-registrar office and obtain a joint conveyance. The entire property has to be transferred to you jointly. Then only you 100 people will become the owner. The question arises here exactly. Is there a provision that 100 people can go together at a said point? The challenge here is that we, even if it is more than 10 also, we can't able to go. Do you all agree with me?
Yes, sir.
So when the matter is very clear, when it is not possible, then what is the solution is available? The solution available here is a very simple thing. This is where you require an association. The association of all the apartment owners, and the association on behalf of the owners will go and obtain the title transfer. Oh, association, that is where actually you require precisely the association. Now, when we listen to the thing, association means it should be a register. Now, four of us, without going anywhere else, we join together. Still, we can call it association. Constitution of India permits it. But law do not recognize a four of people or five of us standing together and calling ourselves. It is only considered as a group of people. It is not an association. So then association means what is to be done? Association means you should register under the specific enactment. Now let us understand here what are the laws are available for registration of an association. Association registration is available under the Societies Registration Act. Second thing you should remember very clearly, company which we are registering is also association of people. It is also an association. Cooperative society with a common interest is again an association. So these are all the registrable associations. Now question arises is, somebody will ask, Karnataka Apartment Ownership Act, there is a bylaw and the association gets registered. To make you further clear about what Karnataka Apartment Ownership Act talks about the association, I would like to show you again the slide. The association of apartment owner means all of the apartment owners acting as a group in accordance with the bylaw and declaration. That means they have not defined here registration. They have defined here all the apartment owners acting as a group. Again, please understand the legal terminology very clearly. This is a group of people, and a group of people have formed a bylaw and a declaration. According to that, it is to be worked. So when it is written in Karnataka Apartment Ownership Act, then it is a registration.
Yes, sir.
The
Yes, sir. Go ahead.
association of apartment owners means all the people working as joining as a group. These do not have a legal existence. Legally, it is not recognized, but a group is recognized by you. So the question comes is, under the Karnataka Apartment Ownership Act, even though there is a bylaw, that bylaw will not give you a registered association status. This is what the government of Karnataka, the law department has already clarified. Many of you may be having the details about this, and we too have about it. And this is what we are advocating always, that Karnataka Apartment Ownership Act is not a registered association. Now coming to Karnataka Societies Registration Act. Now question arises is, under which act Karnataka Societies Registration Act, what is the purpose? The purpose under the Karnataka Societies Registration Act is very simple. For what purpose you can register such association is for social, cultural, charitable, educational, political purposes. You can register association under the Karnataka Societies Registration Act. When we are registering under this, the as a apartment owners, we need to accountably maintain, manage, and have the ownership. Whether such provision is there in the law? Absolutely, there is no provision. And secondly, Karnataka Societies Registration Act membership is restricted to a particular member. It cannot be transferred to another person. So when it is cannot be transferred to the another person, whether the Societies Registration Act can able to maintain the building? Absolutely, the answer is no. So the law states that very clearly. Another thing, in one of the Supreme Court judgment, it has been made very clear. A Societies Registration Act cannot jointly own the property belonging to all its members. Now let us understand very clearly. If as an apartment owners together we are, these are all the owners, collectively we are supposed to be the owner. Whether the such said society can own it, the answer available for Societies Registration Act is no. So even they cannot maintain by collecting the maintenance fee from you. So both are prohibitory under Societies Registration Act. So KSRA society cannot own the apartment belonging to all of you, or the title they cannot have in their name, and they cannot carry out the maintenance. So then what is the solution we have? Then the only solution that we have, the law also makes it very clear that the property belonging to the owner to be held by an association should be a body corporate. Now here the word body corporate plays to you. The body corporate is either a company or a cooperative society. Now what is the advantage of a body corporate? The advantage of the body corporate is that it can sue and be sued in its own name, and it is a juristic entity in all the manner. So when it is a provision is available, a body corporate, it has got a strict policy, strict compliance have to be followed, because it is a members collectively everything have to be done. Many of you have heard how the government is taking action on some of the companies. How they are taking Company Act ROC, Register of Companies, equally strong enough to take action on the company itself. So that is where a company can able to take it forward. And if you form a company of apartment owners for a self uh, purposes, for internal functioning and everything, you can form a company, and later on you can obtain the property belonging to all of you owner jointly. The company can own the title on behalf of the members of their company. Next question comes is, company is a very this one, and we find it very difficulty what we should do. That is where another provision is available, is a cooperative society. Cooperative society also, it is the same thing, similar to that of company, but unlike a company where the company's shareholding everything is depending upon the number of share he holds, in the cooperative society it is not like that. Here every shareholder, irrespective of the number of share he holds, he is likely to have, he will have only one vote. So there is a proper democratic function is available even under the Cooperative Society Act. So as an apartment owner, to own the property, that is to obtain conveyance or to own it jointly, if we form a body corporate, either a company or a cooperative society, builder is liable to transfer to you. When he transfers to you, you become the owner of your property and builder cannot able to claim. This is where the necessary of a cooperative society or a company comes into. It is only to protect your interest of the ownership that you are supposed to explore it. Even though the law mandates that builder is supposed to transfer it. But if you do not form such a body of the apartment owners, such an association of the apartment owners, builder cannot able to transfer it. Now again coming back to the another question, if the builder is not, we are not able to form such association or something, and then what is the remedy for us? The remedy here is available very clearly. The law says that builder shall continue to maintain until it transfers the common area to the association of allottees. It is not only in RERA, even in Karnataka ownership flat also it says very clearly, until after the conveyance of the apartment flats, till he conveys the title to the association of allottees, that is the organization of apartment owners, builder shall continue to maintain. Why these terminologies are used in COFA and RERA? The fact remains very simple. The builder or the landowner continues to be the owner even up after the sale of apartments. After the sale of apartment, builder or the landowner continues to be the owner of the property. Again, the law is very simple. Who is supposed to maintain the property? The owner of the property is supposed to maintain it. So if we are not able to form, or you are not formed it, the builder and the landowner are supposed to enforce you to form an appropriate association of allottees to transfer the title in your name jointly, or they both are, either landowner and the builder both are responsible to maintain until conveyance. So when we are very simple, why we should jump into forming a 1960s society and maintain the building? Why we should apartment owners unnecessarily join, call themselves as a owner and association and start maintaining, when the law is very simple. The builder is supposed to maintain until the conveyance is being done. It is his responsibility. If at all we enter into that particular area, we are doing mistake at this stage. So the awareness should be here. Every one of you should take home, should be to you, is that you will not maintain the project until the builder legally transfers it. So the solution, this is where your society association is required to obtain, and this is where the things that you need. It's proper society is required, a cooperative society is required, a company is required to obtain the ownership. Once you obtain by forming appropriate association, then who is supposed to maintain the property? Owner of the property. Now, who is the owner? The owner of your property right then becomes your association. Who are the members of the association? All the apartment owners are the members of the association. So there is a legal binding gets created that every apartment owner has to proportionately contribute towards the maintenance and upkeeping of the apartment. By forming an appropriate cooperative society or appropriate association, thereby obtaining the conveyance, thereby the state association gets a right to maintain the project because it is their responsibility. So we should have very clear idea here that the law is very simple and very clear. Builder shall continue to maintain until it is transferred, and transfer can only happen in case of a larger project. Once the said association becomes a body corporate and obtains a transfer, and the said body corporate members are the apartment owners, they are liable to contribute towards upkeeping. So this is where association is required from apartment, that is a living space, to getting converted into a immovable property as a property. Conventionally, we call it a property. As we stated, you will all agree that it is not a property on its own. So now once you obtain jointly, the building and the land remains with you, with your society. You being a member of your society, the entire thing remains with you. And from there, you become the owner. So you are liable to maintain it and you are liable to pay the outgoing charges only then. Until then, the law is very clear. The builder has to maintain it. So I hope all of you understood what the apartment is, and also you have understood why there is a necessity of an association. Have we reconciled this here? Then to own it, we need to form an association. The association should be a body corporate. Body corporate will be a company or a cooperative society. So once if this is clear, then we can move forward what the things are. Why repeatedly we say about, there is another point I would like to give you. What is property? The definition of a property, you should understand. Yeah, please understand. Property means land and the building and all immovable improvement structures thereon, all owned in free and hold in or in a lease basis or occupant under any law relating to the land revenue easement right and appurtenance to the belonging thereto, and all articles of a personal property intend to be used in connection with now herewith therewith can have been which have been or intended to be submitted to the provision of this act. Otherwise, the property means what exactly it is said here: land and the building. Does any one of your sale deed contains the land or the building? Please verify your all sale deed contains only the description of your apartment. The apartment is an individual living space. That's all. So building, how many buildings in a said project, how many buildings are there, and how many buildings, how many lifts, how many fire equipments they have provided, everything, nothing contains in that. So here the requirement as per the law is individual apartment will be owned by you, which you have already done. So the question comes, is this property means land, building and the title, everything has to be collectively owned by your association. Then only you become a property owner. Then only you become the property to be maintained by you. Otherwise, individually you are maintaining your apartment. No question arises. Then who has to maintain outside the apartment? It is the owner of the project, owner of the property is liable to be maintained. And this is where you get your ownership right. Secondly, to obtain this ownership right, you need to form an association, that is a cooperative society or a company, which are body corporates on the other end. From there, you can own collectively. Many a time it so happens we advise the people to go for a cooperative society. Is it necessary that I should form a cooperative society? The answer is no. I can form a company also and I can follow all these things. Then what is the problem? Problem or nothing is there. The only thing is inclination from the home buyers is essential. So builders can convey to your company of apartment buyers, owners also. So how it is to be done? By registering a company. Then why the people don't use it? The answer here is very simple. The legal compliance to the company to register, it is little bit tedious and lengthy one. But whereas if I form a cooperative society, some things are simplified. One. Secondly, why we want a cooperative society? There is a reason behind that we say why cooperative society, because a cooperative society dispute directly will not go to the court. It will be adjudicated by the adjudicating officer who is having the civil court power in the authority level itself. They have a power to adjudicate. Why do we need this? Now let us understand. In the apartment, we all know what are the common dispute we have. Number one, apartment owners are not paying the maintenance cost and we can't able to maintain the building. Then what happens? They use all abusive language. Parasite, pokad mein rehne wala, something, blah, 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 blah. And internally fight will start. They can't able to recover it. Then they will go and disconnect electricity and water association. Then the matter will go to the civil court. It will take years to get proper response. Of course, solution is available. But if you form a cooperative society, if a member of the society is not contributing to you anything, or the outgoing charges is not contributed, we need not fight each other here. All that it can be done is the said managing body will give a representation. Initially, before giving a representation, he will write a letter to the member that he is liable to pay so and so money. When he doesn't respond within a specified period, say of 3 months, then I can give a letter or a complaint to the registrar asking that so and so member has not given the subscription fee towards the maintenance. Then what registrar will do? It is his duty to resolve the grievances or a dispute among the members. That is the job of the registrar of cooperative society. He will serve a notice. 1 notice, 2 notice, 3 notice. The first job remains of the registrar is to protect the financial health of your society. So he will give a direction to make the payment. No, he will not give. Then what will happen? Nothing will happen. You don't have to worry for it. It is a duty of the registrar to recover. So he will also serve one notice, second notice, third notice according to the law. Then the fourth notice, when the money is not forthcoming, the registrar will attach the property and send the attachment order to the district district commissioner to recover the payment. Am I making clear here, all of you?
Yes,
We
sir.
are not going to disturb the apartment owners. We are going to give a letter to the registrar. Registrar in turn will attach the property, and then the DC will come to recover the money. Whether he throws him out of the house or he auctions it, somehow it is a duty of the district commissioner to see that the society's health is maintained. So the money has to be recovered by the DC. That means government is coming to rescue you without fighting each other in the building, without disturbing their peaceful possession, along with the interest. If it is a cooperative society, we can recover the money without hurting anyone. हमको किसी से झगड़ा लफड़ा नहीं चाहिए. हमारा पैसा चाहिए, हमारा पैसा दे दो बस. यदि नहीं देते हो तो हम कंप्लेंट देंगे, वहां से पैसा आना चाहिए सूद के साथ. If they are not giving money, it is a DC who will come to rescue you. This is one story that we come across in the apartment, which is quite common. Then the second story, management. They are swindling money. वो झूठ मूठ का अकाउंट दिखाते हैं और पैसा बना रहे हैं. This is a common complaint, isn't it?
Yes, sir.
Hello?
Yes, correct, sir.
Yes, sir.
It's a common complaint. Now question comes is how to address this. नहीं सर, वो जनरल बॉडी इज अ डिसाइडिंग अथॉरिटी. सर जनरल बॉडी में उसी का ग्रुप का लोग है. देयर पीपल आर ओनली देयर. एवरीवन विल से पास and they are swindling money. In this regard also, if it is a cooperative society, your rights and everybody's rights are protected. If out of 100 people or out of whatever may be, one person writes a complaint to the registrar, you are paying your money and everything, and you are bringing to the notice that there is a malpractice is taking place, and sometimes the board is also passing just like that. Here the registrar will have a power to go into the details, and he will appoint for an independent audit. There is a department itself is available under the Register of Cooperative Society. Audit. They will conduct an audit, and if there is a malpractice has been done, if there is something has been done, then they will submit a report that so and so have committed the fraud, or they have siphoned out the money. Now this money, when it comes, registrar will serve a notice to the board of directors to refund the said amount. It may take some time, but however, there will be advice will come, so and so amount has to be refunded back to the society by the board of directors or the involved people. So once that letter goes, if they don't pay, again the question comes, is there also the registrar has a power to recommend for a recovery of from the concerned person, refer the matter to the district registrar. District registrar will come to recover the said money whichever has been siphoned out. So in this regard, most of us, we are a middle class people. We can't afford to go to the court. We can't fight many things. So in that background, a cooperative society becomes a valid tool for us if we register our association as a body corporate, as a cooperative society. This is where we invariably advise you to register cooperative society. Whether such things are not available in the company, well, in the company, similar status are available, but there the situation is slightly different, and complicated. They have to identify, piercing the corporate veil, they call it, who are involved into a malpractice. They need to be identified. There is a huge expenses involved in such cases from everyone. So company in that background will be a little bit negative compared to the positive side of the cooperative society, that what we are going to have. So this is where it comes to you, that why you should form company or a cooperative society. More especially cooperative society will facilitate all of you to have the ownership.
Anilji, is it a right time to ask a quick question?
Just a minute, sir. I will finish it, then you can ask me. I have come to an end.
Yeah, thanks.
Questions can be asked in the in-call message. I'm recording it, and in the end of the session, Mr. Kalgi will attend to all the questions according to the order. Please write down your question. Thank you.
Lastly, I would like to say one word. Apartment is a living space that we are buying it. Collectively, we are supposed to own the property. Sale deed that what we have is not for the property but for the apartment. So collective sale deed or a conveyance deed has to be obtained for the property ownership and maintenance thereby, until the builder conveys the property to the association of allottees or association of apartment owners that is formed as a body corporate, cooperative society or a company. Builder shall continue to maintain the building. These are all the law requirements that we should know. So cooperative society and a company, that they can obtain it, and on obtaining the conveyance they can start maintain and charge the maintenance charge to the people, and thereby any dispute arises it. If it is a cooperative society, it is a deputy registrar of cooperative society or a registrar of cooperative society who is a competent authority to adjudicate any monetary aspect that you are finding or any service aspect you are finding. Everything solution is available to you in the cooperative society itself. So the necessary has been understood for ownership and for a peaceful. It is not an independent property that we are buying. We have purchased a collective property. So with this, I have tried to cover what is apartment and how the apartment should be owned and how the maintenance to be carried out. If any question on this, you are welcome now.
Thank you, Mr. Kalgi. So, for enlightening session on the aspects of
Check it.
apartment issues. Irani, 1 second, Malka. So then, in the meantime, so thank you very much for patiently understanding it, and then the various aspects of the issues which we are facing today.